Resolving legal disputes is hard enough without having to worry about how fees and costs will be handled. That's why there's California Rule of Professional Conduct 1.5. Rule 1.5 contains guidelines about how attorneys may and may not charge for their services. The rule prohibits lawyers from charging fees considered unconscionable and identifies factors to consider in determining whether a fee is unconscionable, such as the time and labor required, the novelty or difficulty of the legal questions, and the amount involved and results obtained. Some fees are completely illegal. For example, state law strictly limits attorneys' fees for mortgage loan modification services. While having a written fee agreement is always advisable, it's required in certain situations. For example, whenever the client's total expense is likely to exceed $1,000, the lawyer must provide a written fee agreement. Contingency fee arrangements, in which the client's obligation to pay is conditional, also require a written fee agreement. And while contingency fees are allowed in many situations, they're prohibited in all criminal cases and in certain family law cases. Rule 1.5 also prohibits lawyers from charging non-refundable or earned-on-receipt fees unless the engagement is a true retainer. A true retainer engagement ensures the lawyer's availability for a period of time, regardless of whether they perform any legal services. True retainer fee agreements require the client to confirm in writing that they understand they aren't entitled to a refund, even if the lawyer provides no services during the retainer period. For routine services, such as a simple estate plan, lawyers may charge a flat fee regardless of the amount of work or time involved. Attorneys can request payment of flat fees in advance, but it must be refundable. For most people, resolving a legal matter is stressful. Beginning with a clear agreement about the fees and costs involved helps relieve some of that anxiety.